Good morning. My name is Brett Eliason. I'm joined here by Tyler Seltzer, and we're both associate attorneys at the law office of Jacob E. Martinez. Today we're going to talk about a very common crime that we see here in Colorado, and those are gun crimes. One of the more frequent crimes that we see is what we kind of call gun in the airport. Why don't you talk to us about that, Tyler?
Gun in the airport is, it sounds like a pretty outrageous offense, but it actually is something that occurs pretty frequently. And it either occurs whether somebody intentionally or more often unintentionally is going through TSA at DIA and they're bringing some kind of firearm with them. And most often than not, it's because they grabbed the wrong bag in a hurry at the end and didn't even realize the gun was in there. Either way though, when you are charged with this, it's charged as an airport infraction or an infraction of airport rules and regulations. DIA is in the city of Denver, and this is a violation of a Denver municipal offense. So these offenses are prosecuted by the Denver City Attorney's Office. And typically, they resolve themselves in a rather common fashion, and it comes down quite a bit to whether you have any criminal history, whether you've been charged or convicted of anything in your past. If you do have a pretty clean history, the most likely outcome would be some kind of deferred judgment agreement. Brett, can you tell them a little bit about what a deferred judgment is and how that might be applicable in these kinds of cases?
Certainly. A deferred judgment is a really awesome situation for a criminal defendant to find themselves in if the district attorney is willing to extend that offer. During plea negotiating, a whole realm of possibilities exist, including a deferred judgment. Under the terms of a deferred judgment, a criminal defendant is going to plead guilty up front, but the conviction's not going to enter at that time. The way I describe it to people is it's hovering over your head like a cloud. And as long as you do what you're supposed to, which in this case would be not getting in trouble, taking a gun class, and doing some community service, as long as you complete those things, the cloud just kind of dissipates. Your guilty plea would be withdrawn, the charges would be withdrawn, and the case is immediately sealable from your record. And we've touched on record sealings in a prior video, but it's a very powerful tool to allow a person to hide a criminal offense on their record from everyone except law enforcement, courts, and other agencies of that nature.
That makes a lot of sense to me, and it's something that should be pretty basic, but it's something we're here to talk to you about if you have any questions about that. And it sounds like these cases, they all resolve themselves, and it sounds like the deferred judgment isn't such a bad outcome. But with these cases, with this charge specifically, if you are convicted of this and you do not get a deferred judgment, you could be fined up to $999 and you could serve some time. So it's a serious offense. It's something that you should reach out to an attorney, someone who's familiar with how to prosecute these or how to defend these cases, someone who's familiar with the different offers that are going to be on the table. And both Brett, I, and Mr. Martinez are here to talk to you about these cases.
And while we're on the topic of some of these gun crimes that we see, why don't we touch a little bit on illegal weapons, whether they be illegal guns or even just different weapons that the state has deemed illegal. For example, a firearm where someone has tampered with the identifying marks, the serial number or the maker's mark, any kind of punches that exist from the manufacturer, that actually turns that weapon illegal, doesn't it?
It does. It does turn the weapon illegal. The most common thing you hear is, as Brett said, someone scratching the serial number or someone doing something similar to that. A lot of these offenses, they're charged as prohibited use of a weapon or something similar to that. With the prohibited use of a weapon statute, there's, I think, 5 different sections under which you could be charged. One of those sections is what we call drunk with a gun, and it's a pretty common offense, and it basically just says you had in your possession a firearm, and you did so while you were under the influence of some kind of alcohol or controlled substance. All the offenses under this statute, all 4 or 5, they're all charged as Class 2 misdemeanors, meaning that you can spend up to a year in jail and you can pay up to $1,000 in fine and or kind of situation. So they are serious offenses. Another one of them, for example, is pointing a firearm at somebody in a reckless or negligent manner. And then another one has to do with weapons that actually aren't firearms themselves, but other types of weapons. And Brett can tell you a little bit about those.
Yeah, so if you've ever been in a mall and you see one of those kind of kiosks pop up that have all sorts of different knives and blades and weapons, and the idea kind of comes to mind, what is actually legal in the state of Colorado? A switchblade is illegal, nunchucks are illegal, brass knuckles are illegal. And I've actually represented a client who purchased brass knuckles from the mall and was stopped 10 minutes later with an illegal weapon, those brass knuckles. So you do have to be aware of what is legal for you to own under Colorado law. And throwing stars, nunchucks, brass knuckles, the projectile blades where it kind of shoots the blade off, all of those have been deemed illegal under Colorado law.
So other than, gun at the airport, drunk with a gun, one of these other prohibited use of a weapon charges, another really common charge that we see people getting charged against is possession of a weapon by a previous offender. And Brett's going to tell you a little bit about what that charge is going to look like and typically how those are resolved.
Yeah, commonly known as POWPO, possession of a weapon by a prior offender. That's charged as a felony, and it's concerned with when an individual no longer has the right to bear arms, yet has a firearm in their possession. So for example, if an individual has been adjudicated a felon, convicted of a felony, they have lost their Second Amendment rights and no longer have the ability to bear arms. In addition, if a person is subject to a protection order, or if the Brady handgun bill applies to them, they may also find themselves unable to own firearms. And if they do, they can be charged with a felony. All it requires is that you are convicted of a felony or are otherwise ineligible, and you are found in possession of said weapon. And so it's something where you may want to consult with an attorney to make sure that you do actually have the right to bear arms before you're going to find yourself in that situation of being charged with a felony.
Regardless of whether you've been charged with any of these firearm offenses or weapons offenses that we've spoken about, or even something different, Mr. Eliason, myself, Mr. Martinez, we are all pretty knowledgeable about the different weapons, firearm offenses that you might be charged with in Colorado, and we're here to talk to you about those. Or if you've already been charged and gone through that process, we're here to talk to you about sealing some of those offenses so you may be able to get those Second Amendment rights back.
Yeah, contact an experienced criminal defense attorney to fight for your rights and to protect your interests today. Thank you.